Our next speaker was here last year. He's a partner with McGinnis Cooper, the same McGinnis that's the namesake of this room. He asked me to keep his introduction really short, but it's kind of hard. He's the president of the Canadian IT Law Association. When I think of him, I think of privacylawyer.ca. That's his website. If you want to find out more about privacy law, it's a very rich resource you can have a look at. And without further ado, with a presentation entitled Privacy and the Cloud for Universities and the Real World, please welcome David Fraser.
Thank you very much. I just have to quickly find my presentation here. Oh, that's great, thanks. Okay, I'm delighted to be invited back, and I'm even more delighted to see this enormous crowd. This is fantastic, as was said at the beginning. I think it speaks very highly of not only just the amount of publicity that's happened, but the interest in privacy. And in the same way that I think we're seeing increased awareness of the number of threats to privacy, and we've obviously just heard about kind of threats via social networking and other sorts of channels. We're going to hear about it, other examples. It's really extremely important that people think about how their information is collected, used, and disclosed in every service that they're using. But we've dramatically seen a significant shift in terms of the way that people interact with the world, moving more and more onto social networks and interacting online, maybe in a more superficial way, but interacting with more people and putting more of your presence online out there, kind of public facing. We're also seeing at the same time a dramatic shift and it's gradual and sneaky in some ways, and it's pretty revolutionary in others, towards something called cloud computing. And being a lawyer, of course, I have to start off with a disclaimer. When I'm going to be talking about legal issues, and I'm supposed to tell you that it's not quite legal advice, but I want you to be thinking about the legal context and the privacy context in all of these sorts of topics. Because I think people often, without thinking, in the same way that probably without even activating their brain, they click on those links and email messages that take them to malware sites. People very often choose to use services without turning their minds to how their personal information is collected, used, or disclosed, or how it's managed. Or even without thinking about what are the risks associated with these sorts of services. And so a lot of people kind of go into using different services blindly. Probably a lot of people just activated Facebook and went on to Facebook without thinking about that so much. Other people kind of thought really long and hard. My mother's been on the fence for, I think, 3 years now about whether or not she's in fact going to go on Facebook. My mother-in-law made the big plunge 2 years ago. And so while a whole lot of people go into things without thinking about privacy, others tend to be at the more paranoid end of the scale and may not be thinking through every single different aspect of it. And so I'm willing to bet that everybody in this room, almost without exception, is a user of cloud computing services in one form or another. And you might not think of it in that sense. So we'll go through a little bit of a definition. There are dozens of definitions of what is cloud computing. And then I'll talk about some examples. So cloud computing, one of the classic definitions, it's a distributed computing architecture, so using a whole bunch of computers that are all over the place, in which data and applications reside on servers separate from the user. So it's not the computer on your desk. All the processing of information happens somewhere else, using data that's sitting somewhere else. And it's generally accessed via the internet, or it can also be accessed via private networks, but usually it uses at least internet working protocols. Applications and data are generally accessible from anywhere, provided you have a net connection. And these are taking off dramatically. So if you are a user of, and I have a number of examples in a later slide, but if you use webmail, for even kind of Dalhousie webmail, that's a form of cloud computing. If you have anything like a smartphone, absolutely an Android phone, most of your data is actually resident in the cloud. If you have an iPhone, a huge amount of your information is on the cloud. Use any sort of Gmail, Hotmail, all those sorts of services, you're taking advantage of, although you may be using a $3,000 top-end computer, 99% of the processing related to that is happening on another computer. And we've seen, actually, things go a bit of full circle if you step back and you look at it in a larger kind of historical context, where we started out, the initial advent of computing, computers were enormous, they filled up entire rooms, and people either kind of prepared their punch cards remotely, went into the room and ran them on the machine, but then it advanced to where they were logging into that remotely using terminals. And so it was time shared on those systems. And so only the big companies like IBM and others had these enormous systems, and they would sell time to corporations who would then log into them remotely. And then we moved to an era where the corporations could have these mainframes, and they were accessed by the propeller heads right at the mainframe or remotely through dumb terminals. Then Microsoft changed everything with the personal computer. Kind of this time the computer is personal. Everybody ended up with a computer sitting on their desktop. And that computer had a significant amount of computing power. It ran all of its programs locally. Generally, most of the data it used or processed, other than in large enterprise systems, was right there on the desktop. And so everything was contained within the four corners of that particular desk. And now we're seeing a dramatic kind of shift back into time-shared mainframes, or at least something that's an analog to that. Because if you're using Gmail, Hotmail, Yahoo Mail, you're logging into computers that you don't know where they are. You can log in using a state-of-the-art computer, as long as it can run a browser, or a smartphone, or even a dumb phone, as long as it has a browser, because all of that processing is taking place somewhere else. Your data is not resident on your device, it's somewhere else. And so kind of the very first basic ones, the advent ones, were just the webmail services. It used to be that people, in order to, I remember when I had my first email account, other than when I had to log into to a Unix shell, when I had my first kind of personal email, I actually ran software on my desktop, and I downloaded messages and cleared them off the server, and I managed my email box. It was right there. If something went sideways, that was my own problem. I was going to lose the whole thing. Well, we're seeing a shift away from that, even towards a hybrid model where people they might have local cached copies of their messages, but they're relying on the fact that somewhere out there, somewhere else that they can have access to, are their email messages if something goes sideways. And increasingly, we're seeing users who want to have access to everything that they do, regardless of how they're logging in, whether they're logging in from a Mac, whether they're logging in from a computer in a business center, in a hotel somewhere, or they're logging in from their smartphone. And so we've seen the significant adoption in kind of the mass market, the consumer market, and these are 99.9% free. You have the Gmail, the Hotmail, the Yahoo Mail as the prime examples. Google Documents and Google Apps have taken off significantly in the last little while because it's a virtually complete Office suite that you don't have to buy software for. It's completely free. You just log in with a Gmail account, and all those documents are there, and you can share them with whoever you want to, or you can lock them down privately. It's extremely convenient. Microsoft is moving into this space pretty aggressively with their full Office suite, making it available online. And they're doing a little bit of a hybrid model as well with local access, local storage of documents if you want to, using their cloud service. And Google's actually following suit in that sort of way. But if you think about it, Facebook is a cloud computing service. Pretty well anything that you log into, that you can log into regardless of the device, and the information is there and the processing is taking place there, that's a form of cloud computing. And so all of it has taken off extremely significantly. And that's in the private space. We're seeing also in what we call the enterprise, very significant adoption of particularly customer relationship management software like Salesforce.com, which has been incredibly successful in providing very sophisticated software that integrates very well with existing local infrastructure to provide information for sales forces regardless of where they are. And so it means that your local IT people don't have to administer it, which is a huge benefit. So this is really taking off. Adobe now has Photoshop.com, which is one of the first, well, it's not quite professional grade, but we're seeing Photoshop.com and Picnic and other services that are allowing you to edit photographs online, which it used to be that all the sophisticated graphics and all sophisticated graphics editing software had to be resident on your computer. Same with video editing. More and more of the things that you might be chained to your desktop for is going online, and all of it can be accessed through just a simple browser. And this has become an incredibly efficient way of providing you with access to the sorts of things that you want to have in your computing life, if you can call a computing life a life, and you can do it regardless of what platform you're using. You can be a Linux geek, and you can, as long as you can run a browser, you can have access to that. And it's virtually identical when you log into it. So all these different pieces of software. And one of the great things is that you're no longer tied to a particular desktop. Users, particularly young users, want to be mobile. They expect to be mobile. They get really upset if you chain them to a desk. And so this has become the expectation. So all these things are moving to the cloud. Well, and I think consumers, by and large, as soon as they experience the benefits of these sorts of services, they move to them pretty quickly. But they're not turning their mind to the privacy issues that may be inherent in it. It's only at the large organization level, when they're looking to shift kind of wholesale or even just parts of what it is that they're doing to the cloud, that they really start to scrutinize what are the privacy issues. And there seems to be also a bit of a knee-jerk reaction that says, oh my goodness, all of a sudden we can't hand this data over, that there's this significant aversion. And there's a belief that, which may be very well-founded in some organizations and less well-founded in others, that suggests that if you can go and physically touch your data, or if you can go and touch the server that your data sits on, it's actually safer. Or you have a better sense of accountability for it. That if you can see it, you can imagine it, it's not just kind of thrown to the four different winds. But with cloud computing, you're not able to do that. You're having to trust somebody else to manage it, to provide you the service. You're doing it to get a particular service, but you're going to have to trust them to secure it and love it and cuddle it in the exact same way that your own IT people would. And that's a bit of a leap of faith. And that relates to privacy, that relates to security, it may relate to uptime and different things like that. And then you lay on top of that the fact that as soon as information goes into the cloud, it's on the internet, and the internet is inherently borderless. And the Supreme Court of Canada has said kind of on the internet, there's neither here nor there. It's all here and there, which is a pretty good statement that, okay, there's no sense of, in fact, physical boundaries when it comes to data online. It just breezes across the border like any other bits of data. And so if your information is up there in the cloud, you may not know. Now, in some cases you do, but in many cases you don't know exactly where that information is. If you're using Gmail, that information is likely in a data center in California or Oregon or North Carolina. If you're using Microsoft, it's likely in Washington State, California, or South Carolina. But it may be in Europe. It may be in Asia. It may be in other places. But you don't know exactly where it is. But if you're a system administrator, you have comfort in the fact that it's sitting there. And kind of the flip side of that, as a user, I get some comfort of the fact that I've saved something on my hard drive, but I've had enough hard drives crash that actually makes me a little bit nervous. And so it kind of cuts both ways. Another concern, particularly for the larger organizations that turn their mind to it, who here has read the terms of use for Gmail or for Hotmail? Has anybody in this room? I'm impressed. I teach internet and media law at the law school, and for the last 3 years running, I've asked that question. Nobody has. I have, but I'm a bit of a geek that way. But it shows the fact most people don't take the time to perhaps think about these things, or those things are drafted in a way that are hard to understand, although Google's made a really good effort to provide kind of plain language information. But I think a lot of people don't turn their mind to what is the bargain that I'm striking. And because free isn't always free, most of these mass market services, the consumer-focused products, the organization isn't going to take a whole lot of responsibility for what it is that they're offering. And if you're the IT manager for a large organization, if you're the CIO, that makes you very nervous, that you're moving all this important stuff, personal information, stuff that makes people vulnerable, people nervous, freaks them out. and you're handing it over to somebody and they're saying, yeah, we'll try to take good care of it, but stuff happens. So you're not going to be happy to do that. And then, kind of as a final point, the information itself may not be portable. If you've dumped all of your information up into a system, and then all of a sudden you don't like it, or all of a sudden you're discovering that it's not going to grow with you, or it doesn't meet your needs, or all of a sudden the company turns evil, or for some other reason you started using it because it was free and they announced all of a sudden they're going to start charging you a lot. If you can't take your data back with you, they're holding you hostage because they're holding your data, which is extremely important. And so these are key issues that need to be thought about. And it's not kind of the sky is falling, the sky is falling, the sky is falling, because there are reasons why people want to move their data there, and it's not just a matter of convenience. There are other aspects. There are privacy benefits that that a whole lot of people don't necessarily turn their mind to. One person just recently pointed out to me, and although it's not on my list, this is a key one. Information that's hosted using these services, kind of the reputable ones, is much more reliable. The uptime for these services is pretty significant. And part of using, it's not so much a privacy concern, but when it comes to if your information is important to you as a user or to a business for its own business purposes, all of a sudden, if you can't have access to it, you're in deep trouble. I think of the number of times that our Exchange server went down at the office a couple of years ago. All of a sudden, a modern law firm simply cannot operate without email. It's it, kind of grinds to a halt. We have to go look at books and stuff like that. But it's pretty. But you think any sort of organization, if you have that sort of downtime, that's significant. And to fix that, you need significant resources. These large providers actually provide significant for kind of large enterprise service levels. They'll provide you with guarantees of uptime. And they have all the people there who are going to make it happen. Google just announced that their Gmail uptime for apps for education and enterprise users was 99.99%. And that was better than most companies do. And they've actually now rolled that into their guarantee. They have an uptime guarantee of 99.99%, which amounts to a couple minutes of downtime a month, if that. So what are the actual privacy benefits? Large companies are in a better position to secure their data and to secure your data. I think of what's sitting on my computer at home. Not only is it vulnerable to hard drive crashes, which happens all the time, kind of across a large population, but it's happened to me a couple times in the last little while. If it's up with a reputable provider, it's in fact more secure. They have more secure data centers. They have more resources to put into it. I'm willing to bet that overall my data is more secure if Microsoft is guarding it than it is if it's just sitting in my house and my cat's guarding it. Frankly, it's not as likely to have somebody walk away with it. It may be more vulnerable to the sort of attacks of me losing my head and providing my password to somebody else, and they can log in and they can get access to my data. It may be vulnerable to me not thinking and using the same password on a whole bunch of different services in the way that we just talked about or just learned a little while ago. But it's not likely to be stolen. Nobody's likely to walk away with it. And the risk of it being misused in that way is significantly lower. Data is not easily lost. So people want to be portable. So what do people do? They put a huge amount of data on devices like this. They put data on thumb drives. They put data on laptops that they obviously want to plug in a cafe and work on all their information. Those things get stolen all the time. If you lose a laptop in a New York City taxi cab and you call the taxi company to try to get it back, they'll laugh at you. They get stacks and stacks of computers that are left in cars every single day. The number of smartphones that they find that they would never be able to match up to somebody else is staggering. And the number of thumb drives that are left in hotel business center computers and airport lounges and things like that, it's frightening. And then, and that's just kind of people being a little bit careless with their own information. Then you have these massive data spills. This happened a couple years ago. The Department of Veterans Affairs hired a large consulting company to completely, this is in the US, the Veterans Administration, hired a consulting company to come in and redesign all of their systems for managing veterans' claims benefits. And so one of the programmers downloaded the entire database of veterans who are receiving benefits. It includes the name, social security number, address, financial information, so their benefits information, the extent of their disabilities, information on their next of kin, downloaded that onto a hard drive that was sitting on a laptop that, of course, was left in the back seat of the person's SUV when they went home that night. And was it there that morning, the next morning? No, it wasn't. So these sorts of things, the incredible density of information and the amount of information that people carry around with them, it's vulnerable. I am kind of the last line of attack against kind of whatever is information is on my laptop and on thumb drives. If that's in fact up in the cloud, and you're using adequate, robust passwords, and on a clean system and otherwise, that information is not anywhere near as vulnerable from being lost or misplaced or misused. And that's a pretty important consideration nowadays when among the amendments being proposed to the federal privacy law, PIPEDA, is breach notification. If that thumb drive contains any personal information and it's lost, you're responsible and it presents any risk of harm, any risk of serious harm to the individual involved, they have to be notified. And it's pretty embarrassing to have to do that. And it's so easily lost when it's on these sorts of devices. So, and then we overlay on top of that kind of legal issues and legal considerations. That there is a belief, and I'm actually surprised at how pervasive it is, and I think it's because there's been a lot of coverage in the media of legislation regulating a lot of public bodies, particularly in British Columbia, Alberta, and Nova Scotia, but a belief among the private sector that they're not able to outsource or use cloud computing services because they're not allowed to permit the export of personal information. And so in many cases they think, oh, absolutely, we can't do it, which is actually not the case. We have, and I'll talk about these specific laws in a couple minutes, but there is no prohibition in Canada against the private sector use of cloud computing services. That doesn't mean it's fair game. My overall theme, if there's one thing to take away from this, it's that you need to step back and do a full assessment of what are all the risks and what are all the benefits. And if you can identify the risks and if you can mitigate them, then fill your boots, go ahead and use the service. If you can't and they're important, then you're going to have, then you should be continuing to use your own data on your own premises or in a single purpose or standalone or shared co-location facility that's under your control. But in most cases, these sorts of privacy risks can be managed. We have the number one principle in PIPEDA. Well, it's number one. I'm not sure it's the number one principle. But the first principle of PIPEDA is called accountability. And what this says is that every organization that is subject to the law remains accountable for the personal information that they collect. And they remain accountable for that personal information regardless of whether or not they hand it over to somebody else to work on it on their behalf, which would be if you outsource the storage of that or the processing of that to another party, which would be the perfect example of cloud computing. If you do that, you remain responsible for it. You can't outsource that responsibility. So if something goes sideways, if something goes haywire, if there's a screw up, you can point to them and say it was their bad, but legally you're responsible, which means that you need to be satisfied that they can take care of it because it's you who's going to be wearing it. Now, you can put in kind of insurance clauses and all that other sort of stuff, but no matter what, it's going to be, you're the one who's going to be wearing it. And you're obliged to put in place contractual means to hold them accountable to that, to make sure that they remain responsible for it. And so that's a key provision, that if you can maintain accountability to your satisfaction, manage all of the risks that could be inherent in using that service in the same way that managing any risk of using any other service, then you may be able to go forward with it. Well, so what about this jurisdiction aspect? Is there a difference? And what is that difference? Whether your information is stored on one side of the Canadian border or if it's stored outside of Canada. And is there a difference also between whether it's in the United States or in any other country? And I think that there's a tendency, and certainly has been through the media, to assume that all of a sudden if it goes into the United States, it's completely vulnerable to the U.S. national security kind of surveillance state. But you need to actually understand it a little bit better than that in order to make that appraisal. In some cases, jurisdiction is going to be a legal hurdle, as is the case in British Columbia, Alberta, and to an extent Nova Scotia. But you always need to think about jurisdiction as a factor, no matter what. Because, for example, I talked about the first issue is the first principle that you have to have a contract in place. If that contract is with a service provider in a developing country where there is, in fact, no rule of law, where there isn't access to the courts, that contract is useless. And I think it's kind of implied in that it's actually a useful, enforceable contract. And so they may have an incredibly robust infrastructure, but if you can't have access to the enforcement of that contract, you haven't satisfied that particular principle. And there may also be risks inherent in other jurisdictions that you're not aware of, that you need to, before making any one of these decisions, you need to be educated and think about all these risks as clearly as possible. So in some cases, it may not be the absolute roadblock. I think there is a tendency to have a knee-jerk reaction that says, oh my goodness, we can't do this. But think it through. The conclusion at the end may be the same, that you decide not to do that, but it's worthwhile going through the exercise because of certainly access to the benefits of cloud computing, which is not insignificant. If you think about the amount of money, for example, that a university pays to provide email service to students, and the amount of maintenance that goes into keeping clunky old kind of steam-powered servers going in the basement of libraries, that's not an insignificant amount of money that can be put into other areas of education. And so there's simply there's the cash bottom line, which is pretty important. Also, there's additional functionality associated with a lot of these products that is extremely useful. And students, I think particularly younger students, as they're coming in, are going to have the expectation that these sorts of advanced services, particularly collaborative spaces online, are going to be available to them. And I've also seen that if they're not made available to people and they want them, they're going to circumvent your systems and they're going to try to use it anyways. So to the extent that you can make these things available, it's often worthwhile doing. But so the concern is, when you're looking at cloud computing, the number one thing that comes up is the USA Patriot Act. And I speak about this a lot, and in fact spoke about aspects of it last year at that Data Privacy Day. The USA Patriot Act obviously was enacted just after September the 11th. It's about this thick, and it was obviously in somebody's bottom drawers, their wish list, before the attacks happened, because it was passed within a couple months. And the principal characteristics, it didn't completely change. It didn't give significant new powers to law enforcement or national security in the US. What it did was it bumped up some of the powers and broke down some of the barriers, provided some of the tools that were available to counterintelligence to law enforcement and law enforcement to counterintelligence. So it wasn't completely out of the blue. It was a tweaking of an existing national security and law enforcement apparatus. But the principal issues with it have to do with two things. The first one being something called a national security letter, and the second being a FISA court order. And I'll talk about this just very briefly. A national security letter is just a letter signed by a senior Department of Justice or FBI official. It's called an administrative subpoena. If you're on the receiving end of one of these unpleasant letters, it requires you to hand over certain information about, for example, a customer or about a student or otherwise. And it's limited in what information it can ask for. It can only ask for what they call transactional data. So if you're a bank and you receive this, you have to provide information about kind of bank balances and how much money has come in and how much money has gone out. If you're a telco, you can only provide information about what the person's phone number is, who they've called and who they've received calls from, but not anything none of the content of those calls. If you're an internet service provider, it would be information about kind of how many emails and from whom were they received, not the contents of those messages. So it's not for communications contents, it's for information about the person's use of the service, but it's still pretty intrusive, and it also comes with a gag order, so the recipient of it can't tell the subject of the investigation. They also can't, although this has been overruled, they can't seek legal advice on it. The thing that's actually been more problematic, that has attracted more attention, is something called a FISA court order. And the FISA court has been in existence for a while, since at least the 70s, if not before. The Foreign Intelligence Surveillance Act created a court in the United States that's a secret court. It meets in secret. all of its proceedings are secret. The identity of the judges are known, but everything that happens in front of that court, including any proceedings, they're all secret. And what that court does is it pretty well has one mission, which is to issue secret search warrants and wiretap orders. And the decisions of the FISA court have only been appealed once, and I think that's because a lawyer at the Department of Justice just wanted to see how it worked, and it was overturned. And so what these orders can do, in addition to the regular sorts of search warrants and wiretap orders, they can require the recipient of any one of these orders to hand over any tangible thing, which could be a printout of an email message, which could be an entire server, which could be just about anything. Any tangible thing is a pretty broad category of stuff. And that comes with a gag order, so they can't disclose the fact that they received this order to anybody else. Now, they can seek legal advice on it, but that's pretty well it. And so these are seen as being pretty draconian, pretty creepy. People don't like secret courts. They remind them of Star Chamber. People don't like secret court orders. The whole cloak and dagger thing kind of freaks people out. And so this became an issue, or became the focus of an issue for Canadians, because as soon as the FBI has these sorts of powers, the belief is that they can use these against US companies to access information about Canadians. Or, pretty well, when you think there's multiple courses at law school that deal with this whole issue of jurisdiction, any company, any person in the United States is subject to the jurisdiction of US courts and would have to comply with one of these orders. Any company, Canadian, American, or otherwise, that has a presence in the United States would have to comply with one of these orders. Even if one of these were issued to an American parent of a Canadian subsidiary, if it were served on them in the United States, they would have to force their Canadian subsidiary to comply in most cases. So there's a concern that as soon as information gets touched by an American company, all of a sudden it's going to be subject to this enormous vacuum cleaner that is the US national security apparatus. And so it first came to the attention of Canadians through the British Columbia Government Employees Union. There was more concerned about losing jobs to a US service provider than they were about privacy, but they launched this whole right to privacy campaign that led to amendments to the BC Freedom of Information Protection and Privacy Act that prohibits almost categorically all export of personal information out of Canada if you're a public body in the province of British Columbia or any of their service providers. Okay? If the concern is that American authorities may get their hands on it, let's put up a wall on the border, and no public body in British Columbia can allow the export of this information. And they've had to amend it in order to fix some harsh reality. For example, BC's, all the MRI machines in British Columbia are maintained by an American company, and if you can't allow the export of personal information, their service technicians can't log in remotely to make the things work. So they've had to amend it for that sort of purpose. And then they also clued in the fact that it is impossible to clear a credit card transaction in Canada completely. In Canada, all that information goes to the US to be cleared, so they amended the legislation to allow public bodies to keep taking credit cards. So they came up with this categorical, no, thou shalt not. And that seemed to be satisfactory. It's interesting that only a limited subset of provinces have followed in their footsteps. Alberta has introduced amendments, well, it has actually passed amendments to their FOIP Act, but they're actually focused at the mischief, which is we don't want anybody handing over data in response to a foreign demand for disclosure, so we're just going to make it an offense to do that. It will be an offense under Alberta law to hand over information in response to a foreign demand for disclosure that doesn't have jurisdiction in the province of Alberta. And so that's a pretty kind of laser-targeted approach to it. In Nova Scotia, we have a response here, which places, in the university context, it places obligations on the public body and on the service providers. It has limitations on the export of personal information by a public body or its service providers, and also prohibitions against disclosures in response to a foreign demand for disclosure. In a lot of cases, the service provider can't actually comply in reality. That even if they say that they will, what happens is they end up caught between a rock and a hard place. If there's an American service provider that has information, even whether they're in Canada or the United States, because they're still subject to American jurisdiction likely, if they receive a foreign demand for disclosure, they would be subject to significant sanctions if they disobey that court order in the United States. But they're also subject to fines and perhaps potential incarceration in Canada. And so they're violating one law or the other, and it becomes a matter of which one is more scary, the Nova Scotia Department of Justice or the FBI. But I think in many cases, service providers sign on to say that they will do this and hope that it never comes up, and probably in most cases. But one thing that I find very interesting about, if the whole bad guy or the whole problem that they're trying to go after is that they don't want any information about Canadians to go to the FBI, one of the exceptions to this is that law enforcement can hand over information to the FBI. Canadian law enforcement can hand over under any sort of arrangement. It doesn't even have to be a written treaty. And these sorts of things happen all the time under the Mutual Legal Assistance Treaty. And so it's worthwhile to think, okay, well, that's the situation in the United States. That is creepy. We don't want to have that sort of situation happen. Well, if that's your approach, then it is actually just as creepy in Canada, but you don't know it. Canada has done a very successful job of not publicizing its national security apparatus. On December 24th, 2001, happy birthday, Parliament passed the Anti-Terrorism Act. I guess no, they had already taken vacation long before then. It received royal assent on December 24th. And what that did, that's our version of the USA Patriot Act. It amended the Criminal Code, it amended the CSIS Act and the National Defense Act. Did you know we have a secret court? We have a court that's just like the FISA court. Although instead of hiring a whole bunch of new judges like they have in the US, who probably have the cushiest job ever, because they probably get paid about $300,000 a year to hear 1 or 2 applications a day. Instead, we have in Canada designated Section 36 judges under the Federal Courts Act who are full-time federal court judges and then maybe 1 day a week go to a bunker in Ottawa and hear applications by justice lawyers and CSIS officers for warrants. Those courts meet in secret, their proceedings are secret, their records are secret, they're not open to the public, so contrary to the open courts principle, so that perturbs some people. And they can authorize warrants that include interception of communication, obtaining any information, record, document, or thing. It doesn't even have to be a tangible thing. The Americans are limited by whether it's tangible. And they also authorize sneak and peek warrants. So specifically that CSIS officers can sneak into any premises and install anything, observe anything, remove anything, maintain anything, change the batteries out of anything, and do all those other sorts of things. And the subject of that warrant never hears about it. So it's pretty well, it looks like the same duck that we have and quacks like the same duck that exists down there. And then you have to overlay on top of that, there's a huge amount of information sharing that takes place. I'm not sure I think one of the first instances where people might have been given an opportunity to really think about what information crosses the border between official channels, law enforcement and national security, was the Mayor Arar inquiry, where it was made quite abundantly clear that Mayor Arar, transiting through the airport in the States, was arrested and deported on the basis of bad information that CSIS handed to the FBI. There's a huge amount of information that just kind of passes back and forth. And we actually have a formal structure, the Mutual Legal Assistance Treaty, that allows the FBI, if they want information in Canada, they call either the FBI guy who's posted at the US Embassy, calls somebody at the RCMP or the Solicitor General's office, or at the Canadian Embassy in Washington, and Canadian law enforcement are deputized, essentially, act on behalf of and obtain information with warrants and otherwise, or CSIS Act warrants, and hand that information across. So there's a huge amount of information that goes across. And so a lot of what's in the USA Patriot Act is mirrored here. And so instead of having some sort of frightened knee-jerk reaction against these sorts of things, or supposing that somehow there's a boogeyman on that side of the border, there's a boogeyman in your closet without realizing there's also one under your bed, the boogeymen are everywhere. How much does jurisdiction play a role in these sorts of things? But it's not just jurisdiction, because what I think everybody needs to do is they need to take a big step backwards, and they need to get back to the very first principles. In the same way that people are impressed by kind of shiny objects, and, oh, this is cool, we're just going to go off and do it. Take a moment, take a breath, start at the very beginning, and think about what is going on here. Obviously, there has to be a reason to use a service like cloud computing services. If it's going to be less convenient, more annoying, more prone to crashing, you're probably not going to be looking at it in the first place. But if you think it has benefits, think about whether or not you can actually use these sorts of services. What sort of impact does this have on privacy and security? It can be positive, it can be negative, or it can be neutral. And it's only with that information that you can really make any sort of meaningful decision. Because no matter what, the original custodian is going to be responsible for it. If it's sitting in a closet data center in your office, you're responsible for it. If it's in a tier 1 data center in a co-location facility in the US or in Canada or whatever, you're still responsible for it. And there may in fact be other people who can take better care of it than you can. But think about, what are all the different risks? Factor into that, what is the sensitivity of the information? Because not all personal information is created identically. Now, most of our statutes generally treat this sort of stuff, other than the security safeguards part, treat personal information as interchangeable. But there's a difference between your email address and a password that you give to Twitter and your personal banking information that your bank has. All of those are personal information, but there are very significant differences in the sensitivity of that information. If you think about what is the risk, if somebody finds out your email address, what's the worst thing that can happen? If somebody gets your financial information, what's the worst thing that can happen? And they can be very different consequences. So you need to think of it in terms of the context of how sensitive is the information, and then what is the risk to the data? What are the threats that the data is going to be faced with? Are you concerned about hackers? You may have a laundry list of risks. You're concerned about it being lost. You're concerned about losing access to it. You're concerned about it being modified. You're concerned about hackers, crackers. You're concerned about malevolent insiders. You're concerned about most identity theft or most data theft happens internally by employees, current happy employees or current disgruntled employees. One of the most interesting statistics that I heard, and this is kind of anecdotal, but I have no reason to doubt that it's true, during the dot-com bust, when large numbers of companies were shutting down in Silicon Valley, there was a company that was relatively high profile, wasn't quite a social networking company, but had a huge amount of customer information. They announced to their employees that they were shutting down, and within a day, the Staples, the Home Depot, the business depot that was next door, ran out of thumb drives because everybody kind of went over on their lunch break and bought all the thumb drives that they could, so they could, the company's not going to be using it anymore, take it home with them. Most kind of wholesale harvesting of personal information that has happened on behalf of organized crime has been estimated to have been done by insiders at the behest of organized crime. So you need to think about that as these sorts of risks. That is heightened if you're dealing with sensitive information, much lower if you're dealing with a different kind of or less sensitive information. And then think about, what role does security play in that risk? Is this the sort of information that national security people are going to want to have? Is this the sort of thing that they're going to be interested in? So if it's not, well, then you probably don't really have to factor that in a whole lot, other than you're going to have a kind of the human side of it. You're going to have people who might be concerned about it, who don't fully understand what role that plays in things. But if it's the sort of information that might be, or if it does, for example, get into the hands of law enforcement without you knowing about it, that the risk can be really high. But that information is probably at similar risk, whether it's sitting in your basement or whether it's sitting in a data center in North Carolina. The only difference being is that you'll probably get notice of it if it's in your building, because the cops have to show up to your building. Then they show up at the data center and get it from your service provider without you being the wiser. But then, once you have that information, knowledge is power, then you can make the decision as to whether or not you're going to use that service or that service provider. If new risks are introduced, if those can be mitigated, then you're probably good to go. If they can't be, or maybe some new risks are introduced but others are actually pushed down pretty low, well, then maybe you can. But the key thing is that you need to think about all these different things. There is in fact a methodology that has been adopted by most governments in Canada that businesses would do very well to adopt, which is something called a privacy impact assessment. They kind of every time, and you can kind of do this even personally in your own life, although you probably don't want to go through all 36 pages of it, but to think about and document all of the risks involved in any new project that involves collecting, using, or disclosing more personal information, or a different way of managing personal information. And it forces you to kind of go through all these different factors. And if risks are introduced, you have to find a way to mitigate them. Well, if you're looking to use a cloud service provider, here are a number of things that you can think about with respect to your contract. Because although an individual has no bargaining power with a cloud provider, you don't get to renegotiate any of the terms of the Facebook terms of service. But if you're a large enterprise and you're looking to use Salesforce.com or Google Docs for apps or Microsoft's product, you actually do have some ability to negotiate. They want customers. You have more leverage if you're actually paying cash money, but in other cases, they want your customers, for the instance of universities. I think the philosophy behind providing all this sorts of computing horsepower for free to students is that those students are going to graduate from university and continue to be customers of that service, and are going to be people who have seen the benefits of whatever those services are on that day, and will be participating in the first wave of the next level of services. But even with free services, if you've got a lot of eyeballs to provide to them, or a lot of users to provide to them, you do have some bargaining power. And so the key things are, you don't want your service provider using your personal information or your students' personal information for any other purpose. That, look, it's being given to you for the sole single purpose and for no other purpose. You want to have it so that the service provider holds that information in trust. And it's hard to get, many of these things you're not going to get a service provider to agree to, but are certainly worth asking for. The difference about information being held in trust is that they become a fiduciary of that information, rather than just a plain old-fashioned custodian of it. And also that means that in the event of the bankruptcy of the service provider, which is going to be one of those risks that you're going to have to factor in the event of the bankruptcy, you actually have a preferred position. Otherwise, you might rank in getting your data back along with all the other creditors. Obviously, you want them, this is the sort of provision that's in every sort of non-disclosure agreement, no disclosures of your information without your consent. You'll also want to put in there, or try to get them to put in there, an obligation to resist, to the extent lawful, any request for that information. So for example, if they get a subpoena, that they're under an obligation, even if they can't tell you, that they have to resist as far as they possibly can. Liquidated damages. Liquidated damages is one of those lawyer terms for, well, it's impossible to estimate what harm would happen if personal information is lost. So we're going to put a dollar figure on it now as a pre-estimation so that you know what the cost is of losing that. So if you lose for every gigabyte of personal information that you lose or that's compromised, you owe us $100,000. Or it can be higher or lower. But it's worth turning your mind to in advance, kind of what are the consequences going to be of doing that, so that you make sure that the service provider's interests are clearly aligned on safeguarding that information. Obligation to cooperate with any of your regulators' investigations. If you're a public body in Nova Scotia and you're subject to an investigation by the FOIPOP review officer, or if you're engaged in commercial activities and you're subject to review from the privacy commissioner, you're going to want to make sure that you can get your service provider to play along. And also, you don't want them to talk to those regulators without you, because certainly you want to manage, you're the one responsible for that information, you should be the one managing that relationship. Obviously, and this is a statutory requirement, under FOIPOP you have to do this, under PIPEDA you also have to do this, you have to implement safeguards. But if your service provider is going to be responsible for that safeguards, for those safeguards, you're going to want to put as much as possible all of the obligation to do that onto the service provider, particularly if you're relying on their expertise. If they say, oh yeah, we're great at this sort of stuff, we do these things all the time, they're probably in a better position to actually implement it. You set a standard that they have to live up to. And auditability is pretty key. Don't accept any limitations of liability that say, okay, well, look, our maximum liability under this contract is $100,000. You need to say, yeah, no. Maybe if you can separate out liability for loss of data or breach of confidentiality as separate from other forms of liability. You can cap those other forms of liability. But you want a full indemnity. You want a full recovery of all damages or harms, because you're the one responsible for that information. If they screw up, if they're negligent with it, you're the one who's liable to your users. And you want to make sure that you can recover all of that from your service provider. And then you want to make sure that they cannot retain any of your information. If you decide to go to another service provider or otherwise, you want to get that information back. And you want to make sure, just for your own continuity, that you get it back, but you want to make sure that they don't hang on to it. And maybe you can live with the fact that some of your information may be retained as part of their routine backups. you want to understand more about that. If they cycle their disks every 60 days or 90 days, you'll know that after 90 days all your information is out of their system, and that may be fine. Otherwise, might require superhuman efforts to extract or get that information out. So one of the, an additional concept, because principally it's the public bodies that are the focus of this sort of obligation. And I talked about the Pipeta Principle 1 that says it's the original custodian's obligation to maintain accountability. But service providers also need to know, and there are likely service providers in this room. I know we act legally, we represent a number of public bodies. There are a number of contractors. These statutes also push down obligations onto those service providers. Whether they acknowledge those Schedule A new contract terms or not, these are your legal obligations. And so you need to be aware of them, and you need to know what it is that it takes to live up to them. So I believe I have maybe another couple minutes, and I'd be delighted to answer any questions, or if anybody has any comments. If you could speak as loudly as you can, and I'll do my best to repeat the question so that everybody can hear it. Yeah. Sure. Yeah, the question was that to explain the distinction between Outlook on your desktop as a local, using local computing compared to Gmail. And actually, I think Outlook can be two different things. Outlook can be a complete standalone. You can install a standalone version of it that periodically pulls the server, pulls down your mail, and stores it all locally. Or it can be like Outlook is in my office, where it connects in real time to an Exchange server, and all the data is actually held in the Exchange server unless you tell it to keep a local copy for when you're unplugged. And so that's a bit of that can be a bit of a hybrid. You're using a piece of software to access information someplace else, other than a completely thin client, which would be like a browser. And so it's interesting because you can. And the distinction is blurring increasingly. Like we're a Microsoft shop at my firm, so we have Outlook on the desktop. It connects to an Exchange server, but the online version of Outlook, the webmail version of it, has gotten so sophisticated that it's quite similar to if you can work Outlook on your desktop, you can work it through the browser, and it's quite remarkable how much they've been able to move what had been very computationally expensive stuff on your desktop into this interface that you can access as long as your browser meets the standards of that software. You can do that. So, yeah, at the back there. Sure. Oh, thank you. That's a very important question, and it's only kind of privacy nerds like me who kind of dig down into the difference between a transfer of personal information and a disclosure of personal information. Because for kind of just using the way the terms are generally used, they would almost be interchangeable. And privacy legislation usually requires that you get the consent for the disclosure of personal information. So if you're disclosing it to anybody, if they're seeing it, theoretically you should have consent. But privacy laws in Canada generally treat a transfer as being different. And so if you move information to a service provider, and they are going to be acting on behalf of the original custodian, and they're going to be accountable to the original custodian for it, it doesn't amount to a disclosure. It amounts to a transfer. And so in most cases, there isn't an obligation to notify. The Federal Privacy Commissioner has taken the view, which I don't think is grounded in the statute at all, but has taken the view that organizations should notify individuals if they're going to be moving any of that information outside of the country, which is something that the first time she had opportunity to consider it really was in connection with a whole bunch of complaints made about CIBC. CIBC decided, and they've just generally been a big target for anything privacy related for the last number of years, they decided to notify all their Visa card customers that their information was going to be managed in the States. And they didn't do a great job of it, so they ended up having a whole bunch of people calling up and thinking that they had the opportunity to opt out, which they didn't. And the commissioner said, you know, it's a best practice to let people know so that they understand everything, but there's no obligation anywhere else in the statute to make that notification. It's a good thing to do, but I don't think it's a legal requirement. It's one of those best practices that probably should be adopted, particularly if you have a very loud and a stakeholder group that expect to participate in it, and particularly if you can allow people to opt out, because for some people it's going to freak them out. For some people, now they probably need to be better educated in terms of to do a full analysis of it, but if you can give them an opportunity to opt out, that's not a bad thing to do. So. Yeah, question over here? Yep. Yep. It's an interesting point. My understanding, and I was actually asked this question last night, and I haven't had a chance to look into it in great detail. I seem to recall that there was a case where a company went bankrupt, and the liquidator, the executor of the bankrupt estate, went to auction off all the computer equipment, and I guess a customer group or otherwise got wind of it, or it might have even been the Federal Trade Commission in the U.S., and applied to the judge to get an order that all the servers be wiped before that sale took place, which seems to suggest to me, and I don't recall the judge saying you have a duty in every instance to do that, but that probably, so that does mean that's a risk that you might want to consider or that you might be concerned about. If you're outsourcing significant personal information, there are ways kind of around that. One would be to put in your service contract that you actually own the hard drives, and you'll be billed for them, that they put your data on. And it may become a little bit of a legal fiction, but if you're the owners of those, if they go bankrupt, you get those back. And so you can go to the executor of that and ask for them back. Now, on the consumer side, sorry, you're kind of out of luck. But one additional other case, and this came up, it was Pets.com when they went bankrupt, the one with the little sock puppet or whatever. When they went bankrupt, their number one asset was their customer list. And so when the trustees in bankruptcy went to sell all their assets, the number one was the customer list. And a whole bunch of people made noise. The court intervened and said that the use of that customer list before the bankruptcy and after the bankruptcy is subject to the terms disclosed in the privacy statement. And so it couldn't be used for any other purpose other than the reason that you originally got consent for. And the same would be applicable in Canada. Kind of the consent that you've gotten with the data in the first instance is a condition that attaches with the data and kind of travels with the data as well. So, anyways. I think that may be, one more. Sure, yeah, the question was about the secret order that Twitter received from the U.S. Department of Justice related to information about the Twitter account of an Icelandic parliamentarian who has been involved in the whole WikiLeaks thing. And Twitter received a sealed order, and I'm not sure what provision it was under, probably not FISA, but it might have been a subpoena, it might have been otherwise. And they actually applied to the judge to have it unsealed so they could publicize it. And there was speculation that Google probably received the same sort of thing. Google actually in the last 18 months has put up a website that lists the stats for all the government requests for information that they've received and all the government takedown notices that they've received. So they're pretty transparent about these sorts of things. I think that particularly the U.S. government, no matter what, if any of that information, anything related to the whole WikiLeaks thing was anywhere within their jurisdiction, they were going to use whatever tools are at their disposal to go after it. And so it shouldn't be surprising. And frankly, I don't think it would be surprising if there was information in Canada about any of these people, that the FBI wouldn't go through the mutual legal assistance treaty process to try to get it in Canada. I think that the same sort of thing would have happened online or offline. It's much more likely in an online kind of cloud service like Twitter or otherwise that your information will wind up within U.S. jurisdiction. So one of the risks you need to consider, how sensitive is your information? Are you helping Julian Assange leak classified government information? You probably don't want your data in the U.S. Just kind of add that list to your checklist of things to confirm. You probably don't want, and there's a quote from Eric Schmidt, the now former CEO of Google, that said, and this freaked people out, was that if you have something to hide, you probably don't want to be doing it online. If there's something that's extremely sensitive to you, you probably never would have if you were a teenage girl and you had your diary that had kind of everything that you were ever thinking. You probably wouldn't have given it to anybody else to hold it for safekeeping. You want to kind of keep it locked away in your shoebox in your closet or something else like that. If you're dealing with very sensitive information, you probably don't want to let it, even for just psychological reasons, out of control, because nobody is going to care about that information as much as you. And so if it's vulnerable to being sought by somebody, or if it's very sensitive, then that's just one of the factors that you need to take into play. And assume that if it's of interest to an investigation, they will, if they know it exists, they're going to try to get access to it. So, anyways, I have gone over time, so thank you very much for your time and attention. So.